while I've taught on the history and theory of human rights and humanitarianism for nearly 20 years, I am actually only beginning the process of research, and so this for me is a kind of transitional moment in shifting from, as it were, from pedagogy or teaching to actual inquiry. I should also say, perhaps off the record, although we are on obviously, that you will notice that I initially suggested a somewhat different title for the talk. What I had in mind initially is to talk on humanitarianism versus human rights, or why human rights or human rights law is in deep trouble in liberal societies. I was thinking here particularly on the present situation in Great Britain on one hand, where the human rights law is certainly up for being, if not revised, then may possibly be rescinded. And I'm thinking of the reality of the United States, where human rights always had a very tenuous hold on American politics. Now, the striking phenomenon that I would want you to contemplate, and that I would have presented in some detail if I were still a professional academic, and the striking problem we face is that liberal societies, and I'm thinking here foremost of Great Britain, of the United States, but also of Israel and of Switzerland. Liberal societies have a very hard time dealing with human rights, accepting human rights, integrating human rights into their political practice. They tend, as the Swiss or the Genevans did, certainly the British did on a grand scale, they turn to humanitarianism or to an idea of humanity. And the grand project I am interested in is indeed to figure out what the uses or what the utility of humanity is versus the utility of human rights. This is in part a kind of methodological answer to what Kenneth Kmeal, one of the early historians on the history of human rights, had observed, and that is the peculiar discontinuity of discourses of human rights. Human rights appear and disappear as rhetorics, and for that matter as practices over the past 2 centuries. We cannot speak of a continuity of human rights, certainly not of a linear development, but it's a peculiarly disrupted experience. And I think if we break together a history of the utility of humanity and the history of human rights, and why they substitute for each other, why they replace each other, and why possibly they might go together at the end of the 20th century, which in any case is the hope of much of the literature on humanitarian law and on humanitarian practice in the late 20th century as it affects the Red Cross. This is the kind of problem I would like to solve as a research question. Now, in all of this, of course, there's always a surprise. For my assumption, coming in this respect coming out of the 19th century, was that I had to impute a displacement of humanity. The rhetoric of humanity and the rhetoric of human rights, that one displaces the other, and quite forcefully displaces the other. But the fact of the matter is, in the late 20th century, in the context of the debate on the International Red Cross and in the context of the debate on international humanitarian law, this is one of the most thriving debates you can possibly imagine. This doesn't say anything about the value or the merits of this debate or the efficacy of this debate, that it has any effect on anything, certainly on humanitarian practice, but very clearly, where we must impute a relationship in the 19th century, we have an explicit debate in the 20th century, and this debate, at least in one small instance, is the subject of my talk today, which is on humanitarianism, humanitarian law, and human rights, a difficult relationship. So let me start by saying that the introduction to the just issued third English language edition of the ever impressive Practical Guide to Humanitarian Law by Françoise Boucher-Saulnier, law professor in Paris and legal director for Médecins Sans Frontières since 1991, starts out with an epitaph that captures a feeling of unease that accompanied me throughout my preparations for this talk. Boucher-Saulnier quotes Albert Camus, and I quote, "Calling things by the wrong name adds to the affliction of the world," unquote. Very Camusian thought, if you like. The epitaph, however, calls attention to the importance of words, even though the author declares action, practice, to be the unique focus of humanitarians and humanitarian law. Words matter, but the subject of her book, the guide, is practice, action. And I quote, "International humanitarian law represents the ultimate reference in situations of crisis and conflict. It is the arbiter that determines individual survival in the face of violence committed by societies. This body of law is argued and is defended through action, and thus is not the property of lawyers and specialists, and must be known and defended by as many people as possible." Implicit in this argument, if you think through it, is one kind of relationship between words and action. But what I want to say is that as soon as we step away from action, we are in a territory that is, so we must surmise, quite alien to a practice-oriented world. And yet, much of my talk will focus on a very worthy enterprise, and that is the effort to develop general principles for humanitarian law and humanitarian action. I do not want to talk away this tension, all the more since others have argued that, and I quote, "the appeal to the intellect has taken second place, and the philosophy of the Red Cross has been traditionally a matter of rationalizing past action." I think this is wrong, but it's certainly an arguable case. But what caught my attention is the debate that happened to be very wordy and occasionally quite noisy one. It's the debate on humanitarianism and or versus human rights that has accompanied the humanitarian practice of the Red Cross and similar organization, and that has accompanied debate on humanitarian law through the second half of the 20th century. Whether this debate has increased the efficiency of action may be doubted, but the struggle over concepts and words, and no doubt over an appropriate iconology in the community of practitioners, from activists to lawyers, was articulate and visceral enough to pay attention, even if we did not have Camus as our loading star. Now, I should say the main markers for this essay are broader than the actual focus of my remarks. They are, and most of you are familiar with the terrain, they are the Geneva Convention of 1864 and the St. Petersburg Declaration of 1868, the Hague Declaration of 1899 and the Hague Conventions of 1907, the 4 Geneva Conventions of 1949, as well as the first and second protocol additional to the Geneva Convention of 1977. There are more way stations than that, and there is a growing thicket of legal, institutional, and social, as well as political practices. What they amount to is a distinct project which has broadened the mandate, and I quote, to safeguard the basic worth and welfare of individuals in distress in conflict situations. 1977 is emphatically not the end of this development, but rather a new or renewed beginning, a turning point, if you wish, for humanitarian law in the late 20th and 21st centuries, when the range of humanitarian law and humanitarian action was yet again expanding. However, 1977 serves as a suitable end for the particular subject of my talk, the effort to generate some general principles for humanitarian action out of past experience at a moment in time that both Red Cross officials and their critics consider to be a moment, if not of crisis, then of confusion and of disorientation. This is articulated by Red Cross officials as much as by their critics. This crisis of confusion and disorientation in the humanitarian and the humanitarian law community is the background for the debate on humanitarianism and human rights, and the entanglement of humanitarian law and human rights law against the background of social, political, and ideational mobilizations for a humanitarianism that was now increasingly undergirded both in legal and popular practice, and some would say was trumped by human rights and human rights mobilizations. The uses of human rights law in armed conflict in particular have, as some quite critical voices now argue, become, and I quote again, the new orthodoxy in the late 20th and the 21st century. Now, those of you who are versed in the recent historiography of human rights, and especially its American variant, will instantly recognize the terrain we are treading on. In this historiography, the 70s stand out as a pivot. It is the moment, as Moyne argues, of a breakthrough for human rights in general, as well as, we might add, in the particular case of humanitarian law. Except that in the legal, political, and moral context of humanitarian law, this breakthrough is not at all a turn to a new utopia. As the near 800 pages of Boucher-Saulnier's guide suggest, it is quite the opposite. The rise of human rights is not an occasion to shed a utopian past, but to revivify and to re-narrate it. Humanitarian law is old, as all theorists and all participants in the debate would argue. It is indeed ancient, which itself is a rather peculiar construction, which I do not want to deconstruct here. But in fact, if it is ancient, it at least has a very formidable history that covers the late 19th and the 20th century. So, and it is alive in the 1960s and 70s. But humanitarian law is newly vindicated, newly re-articulated with reference to human rights, even if by the end of the 20th century the latter reframes the former, that is human rights, humanitarianism, in order to make the interplay between the two the new orthodoxy. Hence, the study of the dynamic intersection of humanitarian and human rights law in the 70s is less an occasion to debate a by now familiar argument in human rights historiography, that this is the moment of the breakthrough or the invention of human rights, if you wish, than to advance from yet another vantage point the relative or respective utility of humanitarian and human rights law. In order to vindicate this approach, and vindicate this approach in particular against the challenge of practice, I take my cue here from the prefatory note by Michael Mayer, head of the international law section of the British Red Cross, and Hilaire McCoubrey, a legal scholar on humanitarian law, the preface to a chapter of Professor Colonel Draper's very famous British humanitarian law advocate and an activist, Professor Draper's reflections on armed conflict, which is worth quoting in some detail because it tells you what I'm trying, how I tried to rescue this operation. And they say, Meyer and McCoubrey say, and I quote, "The relationship between international humanitarian law and the law of human rights may seem to be an academic issue in the worst sense of that term." And I might add, it is to quite an extent. It may be academic in the worst sense of the term, insofar as the categorization of norms designed to assist the suffering and to alleviate their distrust must seem to be of little importance in contrast to the endeavors to ensure the effectiveness. In one sense, this is true, they argue. But the view taken of the relationship between humanitarian law and human rights ultimately says much about the nature of the endeavors and therefore has a marked effect upon the measures taken for their implementation. In other words, and this harks back to Camus, if we get the words right and if we understand the debate, we find out something about what humanitarian action attempts to achieve. Whether this ultimately helps practitioners is unclear, but if it reveals the nature of the thing, humanitarian practice and humanitarian action, that would certainly be a tremendous gain for the historian. This said, the general questions that concerns me are readily apparent. First, given the presence of a quite formidable legal complex such as humanitarian law with its conventions and its rich humanitarian practice, its institutions such as the Red Cross and Red Crescent associations, and its unique humanitarian appeal like Inter Arma Caritas, none of which is flagging in the late 20th century. Given all this, what is the work that the appeal to human rights does in the latter part of the story? in the late 20th century. Second, in an extension of this line of questioning, I would want to ask what the work is that the appeal to humanity and the laws of humanity have been doing for more than 100 years, when this entire humanitarian complex began to take shape. So, the long and the short of this is, and I'm not actually used to reading a paper, so this is for me a new enterprise. But you know, pensioners have to have their freedom and do explore new things. The long and the short of this is, we have a really intense debate about humanitarian law versus or human rights law that starts in the mid-1960s and continues effectively in the 1990s. By the 1990s, 2000s, it's clear that human rights law trumps or subsumes humanitarian law, or in any case is at least complementary. That would and that complementarity then is up for negotiation. What interests me is what is actually motivating this debate. What is the logic of this debate? What is attributed as utility to humanitarian law and humanitarian action? What is the ground for arguing for humanitarianism? What is the ground for arguing for human rights? This against the background of the injunction of many human rights practitioners who argue all of this is nice and well, but it is fluff. It is talk. It really doesn't matter all that much, because it is practice that matters. And what we do and what we should do is follow practice. I think, and I hope I can convince you, there is a place for this, as it were, philosophy or theory of human rights. And in order to make this case and to essay an answer to the questions I posed, I will focus on Jean Piquet, who rose from the position, and his writing, who rose from the position of Secretary Jurist 1937 to Director 1946, Director General 1966, and then to the position of a Vice President of the International Committee of the Red Cross in 1972. He was the chair of the Legal Commission and an important force in drafting the Geneva Conventions. He is no doubt one of the most crucial personalities in the post-war, Cold War history of the Red Cross. Apart from numerous articles, he most prominently wrote the legal commentaries on the 4 Geneva Conventions of 1949. His Festschrift in the 1980s is a veritable who's who, well, of what? It would be appropriate to say of international humanitarian law, but we have to realize that Piquet was a crucial person to actually propagate and make general this term. He launched it, but he launched it in quite surprising ways. Piquet had published in 1956 a short pamphlet on the Red Cross principles, distilling the defining normative frame of the Geneva Convention and of Red Cross practice. These principles were redacted into and proclaimed as fundamental principles of the Red Cross at the 20th International Conference of the Red Cross in Vienna in 1965. Once again, Pictet wrote the commentary on the principles, as he had done before for the 4 Geneva Conventions. All this is to say that Jean Pictet was a professional lawyer and a consummate institutional actor in the world of the Red Cross organization. As mentioned, we may not want to overestimate the import of these principles, because principles are principles and practice is what matters. And certainly Pictet knew that and struggled with that issue in his commentary. Except, and this is what I am after, that these principles tell us something about the nature of the endeavor. Now, the Red Cross principles are one thing, and this is a debate about the Red Cross principle you can easily follow in the available literature, like Forsyth's Humanitarians has an elaborate discussion of this. You may disagree or agree with him, but overall it is a keen discussion on the subject. But there is another set of principles which Pictet published in 1966 and called the Principles of International Humanitarian Law. This, among other things, among other initiatives, introduced the term. While these latter principles have less to say about the Red Cross enterprise, they aimed to develop a taxonomy of the law of war, of humanitarian law, and the place of human rights, and thus open the perspective to the entire endeavor of what humanitarianism and human rights activism, humanitarian law and human rights law is all about. What emerges from this exercise is a taxonomy, and here you can look for the first time at the diagram before you. A taxonomy that did not last, but signifies a departure that is highly suggestive for the place of the Geneva Conventions in the world of humanitarianism and humanitarian law and humanitarian law. As you can see, if you orient yourself in this rather complex diagram, as you can see, the principles proper to the victims of conflict, which is, properly speaking, the law of Geneva, are now just one principle among 4. They are no longer even exclusively defining the law of Geneva, at least in the ambitious vision of Jean Pictet. Geneva law, residing institutionally in the ICRC and expansive in its own right, now also shares, according to the vision of Pictet, co-responsibility over matters of what we might call, in a future-oriented anachronism, human security. The key provision being that each person has a right to the respect of his or her life, the security of the person, and equal opportunity. All of which, according to Pictet, is protected by the law of Geneva, whose principal characteristic remains that, and I quote, persons placed hors de combat and those not directly participating in hostilities shall be respected, protected, and treated humanely. Now, just as a small aside, you instantly recognize this is stretching the law of Geneva just immensely. It's stretching the law of Geneva, for one thing, from conflict, from war and conflict to peace. For the protection, human security is indeed a matter that extends beyond actual conflict. There are other such debates to be had here, but I do not really want to concentrate on them, though in a discussion we could and we should, because this is kind of the nitty-gritty, the detail that matters if we want to talk humanitarian law. How far should it stretch? This was at the time a debate. This was an issue that was raised in a very critical report in 1975, the Tansley report, which argued, look, the Red Cross enterprise is all over the place. Everybody seems to be doing whatever they want and nobody knows what actually is going on. This is the moment of great disorientation. So I just want to demonstrate that this matters, except that it doesn't matter for my talk all that much because I have other fish to fry. Now, if we move from the center of Pictet's legal universe in this diagram to the left, we find the law of The Hague, and with it the principles proper to the rules of war appearing as separate and parallel construction. And by implication, not under the purview of Geneva, except in a higher sense that The Hague and the Geneva laws are grouped under what Pictet still calls the law of war, because they share in common a common logic that defines both, and that common logic is the proportionality in the use of force. This again is a very interesting construction, in that the head of the Red Cross argues that there is an entire sphere of the law of war that is effectively beyond the purview of the Red Cross, at least in terms of the law of Geneva versus the law of The Hague. They are then integrated, but institutionally this is a rather intriguing argument, because it suggests that the law of Geneva is indeed the law of transnational society, whereas the law of The Hague is the law of transnational state organization, and hence of the UN. But again, this is something worth to be debated. So much could be said about this construction, what Pictet induces as guiding principle for each of the sections. There is quite a bit in these provisions that goes beyond the Geneva Convention, goes beyond The Hague, and that goes beyond the Geneva Conventions and also overshoots reality by far. Thus, if I just may want to point you to the awkwardly worded principles of the ratione conditionis restrictions, they come alive only if we realize that Pictet uses this to call for the prohibition, the outright ban of nuclear weapons in 1966. And, of course, of total warfare, ideological warfare, and claims precedent for this prohibition in the Hague Convention and in the Geneva Protocol of 1925. Reason is that the damage a thermonuclear device causes is certainly out of all proportions to the object of the war, since it annihilates everything living over a wide area. Proportionality in the use of force matters. Again, just want to point to these as it were, intricacies of the detail, because this is where the debate, in fact, happens to a large extent, and this is where the orientation over what is right and wrong, what is proportional and what is not, is at issue. Thus, Pictet turns out to be an unequivocal opponent of any form of carpet bombing, which has interesting implications for what happens simultaneously at this moment in Vietnam. Remember, this is 1966, right? However, once again, I'm being drawn into the detail because it is where action happens. But the basic architecture here is of greater interest. Pictet acknowledges that there are two realms in which Geneva has actually nothing to say, or very little to say, even if it can influence things. Nothing to say, at least as far as the law is concerned. It is the law proper, the law of war proper, and the law of peace or human rights law proper, which flank a law of Geneva on both sides, which are a law of Geneva, which has now effectively become the law guiding human security. Although, as I mentioned, Pictet doesn't have the words, nor does he ultimately have the concept. In the grand architecture of national and international law, Geneva is central because effectively Geneva is seen as the law guaranteeing the security of persons. Eventually, Pictet would reconsider humanitarian law and narrow its scope to what he called in 1960, still called in 1966, the laws of war. But he was adamant that humanitarian law, previously the law of war, and human rights law remain separate. In 1975, he argues that what is important is to recognize that the two fields are interrelated and conversely that they are distinct and should remain separate. In fact, he got quite hot under the collar when it came to this issue. But why should this matter? Because he argues that two legal systems are fundamentally different. For humanitarian law is valid only in the case of an armed conflict, while human rights are essentially applicable in peacetime and contain derogations clauses in case of war. Unquote. Besides, he adds, and this is then picked up again and again and again, humanitarian law is so much older. This is where history matters. Ancienity matters. History, or rather age, does matter. Thank you very much. And human rights law also differs, and this perhaps is more important, in the degree of maturity of the instruments and in the procedure of implementations. Humanitarian law is highly developed. It has a case law attached to it. It has a universe of practices attached to it, which human rights law, being young, in fact coming just into existence, doesn't have. Not ultimately the reason why the two spheres should remain separate, because they are, as Pictet argues, fundamentally different sets of law, but certainly one of the reasons. Last but not least, he avers human rights law is simply not neutral, not non-political, and perhaps also not built around institutions like the ICRC, but located in the United Nations in New York, and that is an assembly of states. So, it's this column in the middle that is really of central concern so far. Why does this debate matter? We might think, and probably do not think wrongly, that this is a case of crafty Genevan politics, because clearly Pictet is advancing the cause of the ICRC and defends its humanitarian agenda. But there is a more important point that reveals the essence of the humanitarian architecture Pictet defends. Note first the peculiar wording concerning human rights. He thinks of liberty on the right not as inalienable, inherent faculty of the person, but he thinks of it as an entitlement that is to be respected by powers other than the individual. Life and liberty are not self-evident truths in the humanitarian universe. Rather, life and liberty are to be provided, protected, and guaranteed. This is a philosophical, or in any case an academic point, if you wish, but there are consequences if you argue the case of life and liberty in this way, that is, in the humanitarian way. Because life and liberty are goods that are given and need to be protected, rather than being faculties inherent in human beings, these goods need a protector, and the protector must always stand above and beyond the world of conflicting parties. In times of conflict, for sure, but also in times of peace. Life and liberty, like property, are goods that are given and can be taken away, and hence there must be law that sets the limits of such takeaways. Think of proportionality in the law of war proper, and there must be institutions and actors that develop instruments for implementing these limits. The ICRC is one such institution, and humanitarian law is a law to set the limits. Of course, this puts the onus on Geneva, because soon a new generation of humanitarian, especially human rights activists, will ask what kind of instruments the ICRC and the law of Geneva actually do have at hand. And despite its best efforts, Geneva is found wanting. But the humanitarian logic also suggests very clearly the problem that the ascent of human rights will face. For ultimately, the assumption of inherent rights to life and liberty of a person is mute if the actual person in a situation of conflict is shot dead, or entire groups of people are wiped out by indiscriminate violence. Hence, the very real import of the question, of the humanitarian question, who, if life and liberty are inherent rights, is going to protect the individual and their self-evident truths in times of conflict. Now, Pictet implies that a world of states, even an internationally organized world of states, cannot do that. That is, the world of states may be able to reduce the likelihood of conflict, although there was no indication of that either in the 1966 or in 1975. And hence the United Nations and its Security Council is the proper site for a jus contra bellum, law against war, or a law of a law against war. But when it comes to a conflict, Pictet argues, the only force imaginable, however you turn it, is a non-governmental and societal but institutionally and legally mature force, and preferably the one that is situated in Geneva. The point is not that Geneva matters, that's the institutional infighting. The point is, how do you actually defend bare life? And Pictet, this is of course Agamben's phrase, not Pictet's phrase, but the point is, it takes a certain kind of institution, and it must be a non-governmental institution. It must be a societal force. It cannot be, by the nature of the thing, it cannot be, by the nature of the thing, a state. The idea that the United Nations could develop such instruments was as inconceivable to him as the idea of globalizing social movements that provide alternative venues for protecting victims by challenging perpetrators in the name of inalienable rights of victims. This is the development that happens right after. And note here what happens, because I think I haven't spelled this out in my manuscript clearly enough. Note here what happens, because this is kind of a subtle difference, but a very important difference, and I hope I can come back to it. If Pictet's humanitarian idea is the protection of the individual, the human rights advocate's idea is a slightly different one. It is also protection, but it's protection by speaking in the name of the victims and attacking the perpetrators. Human rights law and human rights activists like Human Rights Watch, or then Amnesty International, after an interesting period of self-reflection and transformation, will realize that what human rights does that humanitarian law cannot do and will not do is to go after the perpetrators in the name of the victims. Now, today we are yet in another world in which we already criticize this, in the sense that the representation of victims we think is one-sided, it is even improper, it's false. But we are still concerned here with the difference between a humanitarian universe and a human rights universe, and I think we are coming close to that difference. So, let me cut off this line of thought by simply stating what emerges as difference between the humanitarian law argued by Jean Pictet and a future of human rights-driven law of armed conflict. While humanitarian law and its institutions aim to protect victims from perpetrators, human rights law goes after perpetrators in the name of victims and builds institutions to that end. The ICC, the International Criminal Court, would be the classic case for this. You decide if this is a distinction that matters. All I would say is, at this point, is that it did matter immensely at the time, because the debate between humanitarian law and human rights law and their representatives exercised most everybody who was somebody in the world of international law. While I focused entirely on Pictet, on Jean Pictet, and his perhaps idiosyncratic views, it should be clear that this distinction lay at the heart of the debate over humanitarianism and human rights that unfolded in the last quarter of the 20th century. Those of you who would want to pursue this topic further should consult the just published Habilitation, properly a Habilitation in its thoroughness, an academic credential by Gerd Oberleitner, who's written on human rights in armed conflict, law, practice, politics, just issued 2015. I want to put this aside for the last 5 minutes or so, but not Pictet, because this is where excitement truly starts. We have not even touched, if you look at our diagram, we have not even touched the upper reaches, the superstructure, the Überbau that unfolds above the realms of the law of Hague and the law of Geneva, which are properly the realm of statutory law. Whereas beyond that, we enter the realm, well, and I quote Pictet, we enter the realm of folly. Pictet acknowledges for this entire upper part, in humanitarianism, there is mingled a certain amount of folly. To strive for an ideal which, by definition, is inaccessible, and to strive for this ideal with a great deal of realism. So Pictet interpreted, moving into the upper parts of this enterprising diagram, Pictet interpreted humanitarian law as the confluence of two contrary, moral, natural, normative realms. The realm of necessity on one hand, the realm not of liberty but of humanity on the other. This would seem in many ways a superfluous move in a treatise on law, but the contrast of necessity and humanity, as you see at the very top, is a rather ingenious duality, which in Pictet's rendition defined the challenge of modern humanitarianism. This challenge, in turn, is articulated on the ground, in the bottom line, in the bottom of the pictogram, in principles of application. Pictet moved in one short treatise from the most abstract philosophical normative considerations of the realm of international humanitarian law all the way to the fine print, as it were, that is, how principles were transformed into foundational norms, turned into positive international law, distilled into discrete sets of principles, and finally into applications for practitioners. The high end of philosophy and the low end of practice, that is what is Überbau and Unterbau, as it were, the high end of philosophy and the low end of practice, it turns out, have a great deal in common. Practice and philosophy are much more closely linked than a preoccupation with humanitarian law, and for that matter with human rights law, would let on. The realm of law sits in the middle, but above and beyond is another realm, or are two realms. The hell of practice and the heaven of theory, if you wish. And what links them? As we shall see, is sentiment, empathy, and ultimately, most surprising of all, this is repeated over and over again by a professional lawyer, love. Love is the operating principle of theory and practice. Let me explain. At the high end, we find a moral philosophy that preserves from its moral and religious sources only what is rational, what was rational, and what was universal. This is so because humanitarianism, and I quote, is the universal social doctrine which aims at the good of all mankind. And it is humanitarianism that humanitarian law derives from, at least in the version of the principles in 1966. It is grounded, humanitarian law and humanitarian principles, they are grounded in what he discerns, Pictet discerns as common humanity, which in his renditions is a sentiment of active goodwill towards mankind, unquote, and hence closely related to the emotions of pity, a spontaneous movement in the presence of suffering of others, and of charity, an effort required of us to relieve and put to an end the suffering of others. What links theory and practice ultimately is a moral force, which is why, I quote, a lawyer and lead jurist of the International Committee of the Red Cross, which is why, and I quote, the jurists and moralists cooperate in the construction of humanitarian law, which is this realm in the middle. Humanitarian law is always an amalgam of morality and law. Humanitarian theory and philosophy and humanitarian practice, on the other hand, are, and I quote, a sentiment. We might conclude that words and deeds are rather closer together in this architecture than the preoccupation with humanitarian law would suggest. In an extension of this argument on the moral faculty of humanity, Pictet argues that while in the past moral notions were peculiar to certain civilizations, this was no longer the case in the present, because and I quote, the ends revealed in modern humanism all tend to the well-being of the human collectivity, or at least, when war is taken into account, to a lesser evil. This is the reason why jurists and moralists no longer need to be guided by outside direction, but count on values common to all people. This is classically the doctrine of the universalism of humanitarian thought, as it has developed over the last 100 years. Pictet is a firm believer in universality. If law varies from place to place, values and sentiments, he argues, speak a universal language. They are the same fundamentally everywhere. Or in any case, common values can be distilled from the actual experience of people. It is, we might conclude, sentiment. It is sentiment that unites the world. This is a rather interesting and rather difficult idea. It's certainly an idea we will recognize if we pursue this further, which I won't in this talk because I'm coming to an end. This is an idea that will be challenged by the reality of globalization, and that is the reality that people do talk back, that the assumption of universal values and norms is indeed broken by the reality of global conflict over values and norms. What is very much at the basis of the construction of the principles of humanitarian law is itself being challenged in the new global discourse in which everyone talks. And the objects of universalism talk back. Now, the entire exercise, I should be saying, I come to a conclusion, has something of a Tower of Babel quality to it, which separates and integrates realms of law and realms of morality in a ladder of abstractions. You move from practice to high theory and universal values and norms. It is a rather tenuous building, and its line of thinking produced its fair share of obfuscation in the subsequent debate on humanitarianism and human rights, which was just about to commence. Suffice it to say that this is a very influential text, often quoted, often challenged, also often repeated. Pictet's principles were not the first time the issue of human rights and humanitarianism were articulated, but it's the moment at which it moved from the realm of more practical considerations, how and where to insert human rights provisions in the formulation and implementation of the Geneva Convention, for example, to the realm of doctrinal consideration. The crucial signal of the 1966 principles was that human rights as normative principle and as a body of law were here to stay and had a place in the discussion on the law of war. Still, Pictet's exercise and the entire debate that followed were eminently forgettable if it were not for two insights. The first one is Pictet's argument that action for the good of humanity will always be juxtaposed by the need to maintain public order, which in turn legitimates the use of force. Humanitarian law and humanitarians of this ilk are not pacifists. Force, in other words, is not extraneous to society, but its integral element just as much as the empathetic force of what later generations would call nation building. Hence the need for a higher law of humanity that balances humanity and necessity. It is the need for a higher law, which may well be unwritten law, that matters here. We will forget that this comes perilously close to making the ICRC the emissary of the Weltgeist. Instead, what is worth considering is that even in the midst of the turmoil over the Tansley report, a report highly critical of the ICRC, and despite his better sense as a lawyer that leads him from legal principles and preferably positive law to action, that despite all this better judgment, Pictet insists that law is not enough. It may be foolish, it may be folly, but for humanitarian law and ultimately for the law of war and the actions of the Red Cross to come into being, it needs not simply law, it needs not simply empathy, but it needs, repeated again and again, hence believable in terms of Pictet's universe, it needs love. And the foremost love is, I quote again, the love of others. Pictet would come back to this point in his commentary on the fundamental principles of the Red Cross, in which he insists in italics: if a man no longer finds it possible to love his fellow beings, he is lost, unquote. Suffice it to say, I have pretty much read the entire literature on humanitarianism, humanitarian law, and human rights law, and never seen this argument quoted. It is too embarrassing in a way, it seems. But if you think of it as too embarrassing, a highfalutin lawyer speaking about love and love of others. We should ask why. Why does this embarrass? For Jean Pictet, making this argument was most certainly not a holy fool, and yet he felt compelled to go out to defend love as the ultimate principle that underwrote the theory and practice of humanitarian action. I'd say this is the extension of an argument for another time. Henri Dunant most assuredly was a holy fool. And this is the main reason why the Geneva Convention and the institution of the Red Cross were founded in the first place. This said, I would further suggest that Pictet's principles of international humanitarian law are also an indication of an early warning sign that the golden age of the Geneva Convention was facing a moment of incipient crisis. The Tansley Report of 1975 rendered one depiction of this crisis, and there are other signs that things were beginning to change. It is easy enough to see that the world around was changing ever more rapidly and ever more convulsively. The nature of conflicts changed massively. All of these transformations proved to be immense challenges and have typically been considered as the main problem of humanitarian law and the main reason for the transition to a human rights-based law. But much as principles of British humanitarianism, I'm thinking of Amnesty International and other humanitarian organizations, had to be rebuilt in order for the British humanitarian project to continue in the late 20th century. The continental humanitarian project, of which the Red Cross was the foremost expression, had to be reconstituted as well. And let me add, if Pictet's folly is an indication at all, what needed to change was not only the law that had to be adjusted to new circumstances, and the institutions like the ICRC that had to be readied for humanitarian action in the late 20th century and beyond. But what had to change profoundly, and here I picked up the issue of love, what had to change is the regime of humanitarian emotions. In the event, it was the far more unpractical, and Jean Pictet may be quite right, the far less efficient human rights mobilization that generated this emotional energy. The question is, what is it? But that's a question for another day to ask. A discussion of this debate, as well as of the conflicting discussion of this debate, will, I think, by necessity move us back in time to Henri Dunant and his enterprise of creating a unique humanitarian institution. And it leads us forward into the late 20th century, to the rise of human rights. My suggestion is that we should not understand the rise of human rights in terms of the development of law, but we should think of it as a phenomenon of emotions and the emergence of a new emotional regime. An emotional regime, you should understand from what I've argued, and I hope we can and remember, we can remember this, an emotional regime that is not simply focused on victims. Because humanitarian law and humanitarian settlement is all focused on victims. But the issue is one of protection. whereas it needs charity and pity to protect the victim in humanitarian law. It takes very different emotional qualities to represent victims, to go after and to punish perpetrators. Human rights and human rights law in this context changes profoundly its meaning from what it had previously been. It becomes a very penalizing institute. But the limits and possibilities of that and the emotional regime that is behind, to give it its real name, behind naming and shaming, that's really the issue we need to pursue in great detail. What I've learned from this is that, of course, we must look at the law. But both in the case of humanitarianism and in the case of humanitarian rights activism, we must also look beyond law, even if this makes us look like fools. Because talking about love is not an easy thing to do. Thank you.